Good afternoon, everyone. So I'm going to be talking about Practice Note 22, Hottubbing, and Practice Note 23, the preliminary docket ruling. The second one just started January 1st of this year, and the former came about in 2019. So the preliminary ruling docket um, hasn't had much effect yet, given the fact that we've had the pandemic, and there have been some issues, obviously, with closure of the courts. So I'm going to start out with Practice Note 22, Experts Panel on Hottubbing. So hottubbing is a term that really originated in the United States about getting all of the experts together in one spot in order to have the court determine um, the viability of the experts, as well as whether or not it would be useful to have everybody come together, submit their expert reports, and see what can be done in terms of streamlining a trial, especially in complicated matters where there are a number of experts. So this was released by the Chief Justice Rossiter on March the 11th, 2019. So here's the protocol now for the Tax Court of Canada for hottubbing, getting all of these experts together. So I'm going to go through this slowly because I find that there's a lot of intricacies here, and I'll explain as I go. So the first bullet is the judge shall do a lot of reviewing, defining, and determining. Has to review the pleadings, statement, notice of appeal, as well as notice of defense. Define the issues in the pleadings. Determine if the experts are required or to be presented. Determine if the reports have been exchanged in accordance with the Tax Court of Canada rules. Are there any issues with respect to the qualifications of the experts? And if there are issues with respect to the qualifications of the experts, what in fact are those questions? And then there has to be a determination if there's going to be an exclusion from the hottubbing process, whereby this is a case that isn't suitable for doing this. The second bullet point is the judge shall determine if the experts are qualified. Are they qualified to opine on the issues at hand? And if they are, can it be dealt with on a consent basis, having these experts come forward? Or does there have to be a voir dire on a specific issue? And a voir dire is really a trial, a mini trial within a trial. So if the qualifications are acceptable to the tax court judge, the judge has to do another determination as to whether there is any dispute on the report or challenge to it. So these are the questions that have to be asked. What are the challenges and disputes? Do they go to the weight of the evidence? Do they go to the credibility of the report? And do the questions go to a substantive issue that really is one of the matters that has to be addressed by the court at trial? So the next step is for the judge to read all of the expert reports with the consent of the parties. Sometimes you'll have one party have more than one expert report. Sometimes each side will have an expert report. Now, with respect to the fifth bullet point, before the hottubbing panel is set, the judge has to order that the experts meet pre-trial to see if the issues can be narrowed, and they want to address issues of disagreement and see if there's commonalities that can be made. The lawyers and parties have to attend the meeting. With respect to the sixth bullet point, the judge has to set the panel only after all factual evidence has been put on the record by the parties. So for instance, if there are outstanding discovery issues whereby one party has to provide certain documentation to another party, there's no way that the hottubbing will proceed. With respect to the seventh bullet point, the judge shall first prepare the questions for the panel and then present the questions to each panel member. So really it is almost as if they're setting up a panel. And then each expert is going to be asked the same question. And each expert's going to be given the time to provide a comprehensive explanation and expansion on answers so that the judge can comprehend and compare the answers of each of the experts. Now with respect to bullet point 8, after the judge is done answering all of his or her questions, each counsel then has an opportunity to examine that expert and conduct a cross-examination. But there are limits on the cross-examination. And the limits are on clarifications of the evidence that had been provided and answered when questions were answered by the experts imposed by the judge, answering expansion of those answers, and if there are new matters that were raised within the questioning of the judge to the experts, then there's an opportunity for counsel for the parties to ask questions on that. So that really is hot tubbing in a nutshell. I would say that it's certainly not new to Ontario. It's been under the rules of civil procedure, but it is new to the Tax Court of Canada, and it's been something that I've attended CPD programs probably for the last over 2.5 years now, where they've been talking about doing this practice direction that finally came about in March of 2019. So moving on to the more hefty practice note, the most recent one, practice note number 23, the preliminary ruling docket procedure. This is the one that came about by Chief Justice Rossiter on December 12th of 2019. So really what this is a pilot project that's occurring in Toronto and Vancouver, and it's meant to occur for 1 year, so the year of 2020, to see what the outcome is, to test it, and to determine whether or not this is something that really should be instituted, whether it be in the Tax Court of Canada rules or whether it remain a practice note, because it is so difficult to get legislative and regulatory change with respect to regulations. Even though they're a lot easier to amend, it's very difficult to get consensus, obviously, in Parliament. So that's why the Chief Justice issued a practice note on this, because it really was felt with the costs today of litigation at the Tax Court of Canada, not so much the informal proceedings, but obviously the general proceedings, that there needed to be some sort of a streamlining done to allow for an easier way for parties to deal with litigation. So I see that I think we start paragraph 4. I'm going to just go through the first few bullet points before we get to 4. So there's 17 principles, terms, and procedures that need to be addressed in this preliminary ruling docket procedure. The first is that it has to be by way of a joint application of the parties, and it has to be within 120 days of the close of pleadings. So in other words, that's after there has been the service filing of a notice of appeal and defense, and if there is a reply response. With respect to the second point, in terms of the contents of the joint application, the parties have to indicate why such a hearing would be useful, the estimated trial time if it were to proceed to trial, the estimated time it would take for a preliminary hearing if one was granted, what amount of tax it has issued, but not the interest, by taxation year or reporting period, whether there are any Tax Court of Canada related appeals, how many witnesses would be called at the preliminary hearing. If a party wishes to call an expert witness at the preliminary hearing, there would need to be established exceptional circumstances in order for the court to grant leave, and a list of documents by each side that would be tendered at the preliminary hearing, and an explanation as to the relevance of those documents to the issues at trial. In terms of the third point, the Tax Court of Canada would review that joint application and it would make a decision, preliminary ruling or otherwise regular stream. In terms of the restrictions on matters that can be dealt with by way of a preliminary hearing, they really are dealt with under the point 4. So these are matters that are only subject to preliminary hearing. The trial of the appeal is expected to last more than 2 days. The preliminary ruling is expected to last the trial of the appeal is expected to last more than 2 days, sorry. The preliminary ruling hearing is expected to last no more than 2 days. So 2 days is the magic number. Both parties are represented by counsel. It has to be a general procedure, so no informals. The appeal only involves questions of fact or mixed questions of fact and law, so there can be no questions of law at issue. In the case of appeal under the Income Tax Act, either A, the aggregate amount of all amounts in issue is greater than $25,000 and less than or equal to $300,000 per tax year, or B, the amount of the loss that is determined under subsection 152(1.1) of the Income Tax Act, and that is an issue is greater than $50,000 and less than or equal to $600,000 per tax year. And the final point is that in the case of appeal under Part 9 of the Excise Tax Act, the amount in dispute is greater than $50,000 and less than or equal to $300,000 per reporting period. So these are just random numbers that the Tax Court of Canada has plucked and determined that these are going to be cutoffs for the preliminary ruling docket. With respect to point 5, if there's a primary appeal and a related appeal, the tax court will permit them to be heard on common evidence together if the conditions in paragraph 4 are met, if the appellants are the same or related, the issues are related, counsel is the same in both, the related appeal deals only with questions of fact or mixed fact and law, again, no questions of law, and the hearing will last no more than 2 days. In the preliminary ruling stream, there's no examination for discovery on affidavits and no compelled discovery of documents. If you want to rely on any documentary evidence, then you have to make sure that it's served on the other side within 30 days of the preliminary hearing. Only expert evidence will only be allowed with leave of the court on exceptional circumstances. 15 days prior to the preliminary hearing, pre-hearings briefs have to be served and filed, and there are requirements for length and content. Now, surprisingly, with respect to point 10, the tax court will not be bound by legal or technical rules of evidence at the hearing. So it's not that they're going to throw caution out the window and throw rules out the window, but they will be much relaxed, very much akin to small claims court trials here in Ontario, and I'm sure the way that small claims court trials are run across all the other provinces and territories. Just going to move this down. Sorry about that. Oh, no. Okay. In terms of length, it can, again, the magic number is be no more than 2 days. Now, the judge here in the preliminary hearing has to issue his or her ruling within 60 days of the completion of the hearing, and it can be oral or written. And within 30 days of the issued ruling, there are certain things that the parties have to do. The parties shall either file a consent to judgment, agreeing that they're willing to settle on the terms that were provided for in the judgment without costs, or they jointly advise the court that there is no agreement with respect to the preliminary ruling results, they don't accept it, and they're going to prepare a timetable jointly so that the rest of the steps in the matter can be dealt with. If there's one party that does not accept the ruling, then the preliminary ruling judge shall not preside at the hearing of the appeal when it goes forward to trial, shall not participate in the appeal in any manner in the future, or communicate with any judge involved with the appeal concerning anything that was said or done in the preliminary ruling hearing. So as can be seen, it's very much like a settlement type of hearing where whatever happens within the preliminary hearing stays at the preliminary hearing. B, subject to section 16 and 17, the party shall not disclose anything that occurred at the preliminary ruling hearing to any judge involved with the appeal, in other words, going forward at trial. And subject to sections 16 and 17 below, the following shall be sealed and shall not be available to anyone other than parties without an order of the court. So in other words, this is all of the documents and the preliminary ruling itself. So all documents relating to the hearing, transcript of the hearing, if the ruling was issued in writing, the actual ruling, and if it was issued orally, the transcript of the oral ruling. With respect to point 15, if both parties don't accept the preliminary ruling, there shall be no costs awarded. With respect to point 16, if one party does not accept the preliminary ruling and another party does, for the purposes of section 147 of the TCC Rules of General Procedure, the preliminary ruling shall be deemed to have been a written settlement offer served on the non-accepting party by the accepting party 30 days after the preliminary ruling was issued, either in writing or orally. And the restrictions in subsections 14B and C above shall not apply for the purpose of assessing costs. And then with respect to paragraph point 17, notwithstanding subsections 14B and C above, and subject to the Canada Evidence Act, the evidence that's given by a witness at a preliminary hearing may be used for the purpose of impeaching the testimony of the witness in the same manner as any previous inconsistent statement by that witness. And witness, of course, in this case would also include an expert witness and, of course, lay witnesses. So unfortunately, this has not had much traction because it just commenced January 1st. And with the closure of the courts about, I would say, mid-March, it only was in effect for about 2.5 months. So we'll have to see what happens as courts resume and there are more matters that are able to avail themselves of the new rulings. So thank you very much, and I'll pass it back, I think, to David.
Thank you, Angela. It's great. I'm going to just see if Earl, I think Earl might have had a problem with his microphone. I'll see if he can go again. Hey, Earl, are you there? Oh, there's a... Okay, well, nonetheless. Anyways, if there's any questions, people can field them. I realize we're coming close to our 4 o'clock ending time. So you can use the chat or raise your hand with any questions or comments. And we'll give maybe about 5 or 10 minutes to close it off, and then we'll officially end the session. Okay, so I'll leave the field open to comments now or questions. Oh, hey, Earl. Okay, good. All right then. So I think Earl might have a bit of an audio issue. No big deal. It looks like we're at the end here. So I'd just like to thank all the participants, contributors, and presenters, as well as people at CRA who helped us with our presentation. I think it's going really well. And in a nutshell, I think things are actually starting to stabilize from the problems that we had back 3 or 4 years ago that we illustrated with the statistics. And I'm guardedly optimistic that things are getting back on track. So once again, thanks to everybody for coming out, and hopefully we'll see some positive, a continued trend of positive developments.
Great. Thanks, Dave. Thanks, everybody.
All right. Thanks, Earl.